Good afternoon. Welcome to today's TASA webinar, Liability Implications of the FDA Food Modernization Act of 2011. The 2011 FDA Food Modernization Act has been called the most sweeping reform of our food safety laws in more than 70 years. It aims to protect public health by preventing food-borne illness, ensuring the safety of food, improving research on contaminants leading to food-borne illness, and improving security of food from intentional contamination and for other purposes. The goal is to ensure the U.S. food supply is safe by shifting the focus from responding to contamination to preventing it. This act gives the FDA new and enhanced mandates and authority to protect consumers and promote public health. Even as bureaucrats and government attorneys work out the wording of new regulatory requirements, it's vital for both plaintiff and defense attorneys to understand the implications of not conforming to the law. This webinar will discuss critical details pertaining to record-keeping, greater organic food protection, immediate FDA food product recall authorization, establishing product tracking and tracing requirements, tracking and tracing food that has been internationally sourced, and the enhanced capacity to detect and respond to food contamination problems. This webinar will also discuss various possible interpretations of the law. Do tracking and tracing the food products require real-time electronic software systems? Can data be 100% electronic? Progressive step from the electronic signatures. What is the minimum requirement before the FDA can issue a recall, and how wide a scope can the FDA recall span? How much time will it take before the FDA recall agents arrive to issue a recall, and will this create more deaths? Can the FDA take over operational control, including finances, of a food processing plant? The presenter for today's program is Dr. Darrel Suderman. Dr. Suderman is the president of Food Technical Consulting, and he has worked in food manufacturing and leading industry chains for over 20 years. Dr. Suderman has served as an expert witness/consultant for both plaintiff and defense attorneys throughout the United States. Dr. Suderman received his Bachelor of Science and Master's of Science degrees in agricultural education and his PhD in food science from Kansas State University. He holds 2 patents, co-authored a food processing book, and has written over 40 peer-reviewed and trade magazine articles and white papers. He has worked in research and development, quality assurance, and food safety for many of the leading restaurant chains, including KFC, Boston Market, Church's Chicken, Quiznos, Captain D's, Chick-fil-A, and Wendy's International. In addition, Dr. Suderman co-founded Business IQ LLC as a business intelligence IT consulting company, which has been accepted as an official partner of SAP Software Company. A few of his clients have included Foster Farms, Jenny O Turkey Stores, Golden Plump Poultry, Johnsonville Sausage, E&J Gallo Winery, Tyson's Food, Organic Valley. We will take 2 question and answer breaks during today's program. If you have a question that pertains to the program, please use the chat feature, which is found on the right-hand side of the screen. We encourage all attendees to submit questions throughout the presentation. Tomorrow morning, I will send out an email with a link to the archived recording of this program, as well as a copy of the PowerPoint presentation that was used during today's program. We do ask that you take time to fill out the survey that will appear on your screen after today's webinar is over. I'm now going to turn the presentation over to our distinguished guest, Dr. Darrel Suderman.
Thank you. I look forward.
Darrel, hold on for a sec. Let me get you to be the presenter.
And Matt,
oh, you're already the presenter. You're good to go, Darrel.
Hey, Matt, your voice is a little choppy. I hope it's okay with all the listeners. I just want to make you aware of that.
Oh, well, thank you. Yours is a little choppy, too, so if you could just be loud and strong into the microphone. It might be something with our teleconference service.
Okay. So the topic today is going to be the liability implications of the FDA Food Safety Modernization Act of 2011. And I You know, the old saying goes, what you don't know won't hurt you. But that's quite the opposite in this situation. What you don't know is something that food processors need to be aware of, and it can indeed hurt them and hurt the brand value of their companies. I've listed some of my qualifications on this slide that Matt has already went through, but qualifications in my mind are one thing. Experience is more important. And I want to communicate today that my perspective is influenced by the fact that I have written ingredient and product specifications, written food process specifications for food manufacturing companies. I've managed restaurant chain food safety and quality assurance programs and helped the largest organic food company identify and select electronic specification certification document management program. I've developed standard sanitation operating procedures that are used before every startup on a production plant floor, and developed detailed software solutions that led to product recalls. So I come from a very hands-on approach. I'm not an attorney, but I think this information is going to be very, very helpful to you, as opposed to some of the information that's out there on the internet and being sold to people. For example, I recently reviewed a white paper by Siemens, which is about a multi-billion-dollar company in the world, and they really didn't give any specifics, but they're marketing the fact that you need a food defense program, which basically is an everyday language for a food safety program. You need a food safety defense coordinator, which is basically a risk manager that's used that title in a lot of companies, and a food defense partner, which is really a software consulting company. So hopefully, as a result, that'll be very helpful. Now, on this particular slide, I've listed a few of the TASA papers and white webinars that I've spoke at before or contributed to. The first in 2010 was a white paper entitled Protecting Food and Beverage Recipe and Process Ownership. September of 2011 was the first webinar on emerging issues in food product litigation. And then the next webinar in February 2012 was the top 5 consumer liability risks the public ignores. And then an article that I wrote for national distribution of the Trial Lawyer magazine. It was entitled Public Safety Liability for Mobile Food Retailers and Quick Serve Restaurants. As you know, the mobile food truck business continues to grow exponentially almost, and now we're seeing food trucks that are being transitioned into fashion, designer handbags, dresses, shoes, and everything like that. So the whole portable retail outlets are continuing on very strong. Some of the case experience categories I've worked in are patent and trade secret infringement, personal injury from food, retail grocery slip and fall, food company defamation, foreign object contamination, food allergen adulteration, and food recall directive for a $5 million recall for a food company. As a footnote, one of the most vulnerable emerging food safety areas is organic baby food. This has recently come to my attention as a category that is growing so rapidly that most companies, and there's actually around 4 competing with Gerber, that are required to import organic ingredients. In fact, almost 30% of all organic food is now imported, and a majority of that from China. One thing for sure, you never want to mess with the mother's baby. And the implication of that is, and we'll talk about that a little bit today, is that the Food Safety and Modernization Act has got very specific instructions and guidelines and requirements for imported food with other countries, and that actually is a very large component of the old act. What's the purpose of the Food Safety and Modernization Act? Well, the FDA states that its purpose is to protect the public health by preventing food-borne illness, ensuring the safety of food, improving research on contaminants leading to food-borne illness, and improving the security of food from intentional contamination and for other purposes. The idea of prevention is not new. FDA has established prevention-orientated standards and rules for seafood, juice, eggs, as has the U.S. Department of Agriculture for meat and poultry, and many in the food industry have pioneered best practices for prevention. What is new is the recognition that for all the strengths of the American food system, a breakdown at any point in the farm-to-table supply chain spectrum can cause catastrophic harm to the health of consumers and great disruption and economic loss to the food industry. So this slide has two key words, preventing and security. Prevention tilts the debate towards preventing non-intentional contamination. Security tilts the debate towards preventing intentional communication, in other words, food terrorism. For example, processors of all types of food will now be required to evaluate the hazards in their operations, implement and monitor effective measures to prevent contamination, and have a plan in place to take any corrective actions that are necessary. Also, the FDA will have much more effective enforcement tools for ensuring those plans are adequate and properly implemented, including mandatory recall authority when needed to swiftly remove contaminated food from the market. In my opinion, the legal implications mean that the food company is liable for the risk inherent to each and every supply chain link. What is the impetus for Food Safety Modernization Act? Well, the FSMA aims to ensure the U.S. food supply is safe by shifting the focus of federal regulators from responding to contamination to preventing it. The FSMA has given the FDA new authority to regulate the way foods are grown, harvested, and processed. The law grants FDA a number of new powers, including mandatory recall authority, which the agency has sought for many years. The law has prompted, after many reported incidents of foodborne illnesses during the 2000 decade, tainted food has cost the food industry billions of dollars in recall, lost sales, and legal expenses. As for a personal opinion, this new law currently places all burden and responsibility on the food processor and or the owners of every link of the supply chain. Some owners could be the landowner. Another could be the crop growing manager or distribution companies. It could also be the food processor or distributor, the retailer, or those involved in waste disposal. The mandatory recall powers appear to be unlimited. It could be based on food processors' information and or the FDA inspector. I do have concerns that withdrawal by the FDA could be a delayed process. Common sense tells me that it could take 1 to 2 days for an FDA agent to get to a particular plant location. It should also be assumed that the processor will become aware of the problem before the FDA agent. The role of the agent is open. 1, to expand more product on hold, and it will be based on science. 2, will the FDA have the power to shut down a plant, and for how long, and have access to financial records? You can only guess at those answers. In all likelihood, future regs and guidelines will be solidified through case law, and so it will take time, and it'll take a better shape as litigation moves along. Some of the 2011 FSMA provisions include the improved capacity to prevent food safety programs, the improved capacity to detect and respond to food safety programs, third, to improve the safety of imported food, and then some miscellaneous provisions. In addition to our previous discussion on prevention and security, this slide highlights the application of this law to internationally sourced food ingredients and products. It also highlights a food processor's responsibility to have detection instrumentation, sampling, and detection processes. It implies accurate data logging. Since many food products are uniquely different, best-of-breed detection methodologies will be applied to a product from a related food category. In other words, if best practices or best-of-breed practices that are used in meat could be transferred over to produce, or if it's in produce, it could be transferred over to maybe egg products or dairy products. There doesn't seem to be one necessarily best practice that's standardized over all food categories. But even though these policies move our food supply closer to safer products, one template never fits all because of the nature of the food products and their composition. Very importantly, the FSMA calls for the strengthening of existing collaboration among all food safety agencies, whether they are federal, state, local, territorial, tribal, or foreign. Among other provisions, the legislation directs the Secretary of Health and Human Services to improve training of state, local, territorial, and tribunal food safety officials, and authorizes grants for training, conducting inspections, building capacity of labs and food safety programs, and other food safety activities. Building and leveraging the capacity of these food safety partners is how we can have a well-integrated national food safety system that is effective and as efficient as it could be. As far as improving the capacity to prevent food safety programs, the FDA and the FSMA details a couple key points. One is to issue guidance documents for risk reduction from the most significant food-borne contaminants, and to establish the minimum standards for safe production and harvesting of fruits and vegetables based on known safety risks. The improvement of capacity to prevent food safety programs requires U.S. importers to perform risk-based foreign supplier verification activities to verify that imported food is produced in compliance with applicable requirements related to hazard analysis and standards for produce safety and not adulterated or misbranded. And that is the exact wording of the FSMA. But what could the international reference standards represent? More than likely, they will be measured by one of the following GFSI standards, or what is called the Global Food Safety Initiative standards. And there are several of those standards that have been developed by countries that were mainly international traders, such as Walmart, such as possibly like Kroger and other large food companies, Nestle, Mars, and others. But just to give you a couple examples, and you can look them up yourself. One is what they call the British Retail Consortium. The other is the Dutch HACCP system. Another is the ISS version 5. And another is the SQF, or Safe Quality Foods 2000 version. Most all of these systems were developed so that there would be some standardization, particularly in international trade, because the U.S. food system is quite different. Most of the food companies in the United States are self-audited, or they have representatives that act as an auditing function for restaurant chains such as Wendy's and KFC and McDonald's and others. They have their own auditors, but the auditors do not report to the government. And so this was an attempt for the large companies to do this. It is important to note that the Food Marketing Institute acquired the rights to the SQF program in August 2003 and has established the SQF Institute division to manage the program. They also have developed some global red meat standards. There are also some standards for packaging now that are used on an international basis under the Global Food Safety Initiative. And there's also standards for global aquaculture, Alliance Seafood Processing Standards. So it depends upon who your customer is or your client and what type of food product and where it is throughout the world. You'll need to be aware of these different systems and find the one that applies best to them. Now there's another change going on in the food safety world, and that is to take these various standards that I just mentioned and consolidate them down to one. And that is just going on in 2012 as we speak. But the name of that will be called the FSSC 22000. That is a new standard, and they're hoping that that kind of grabs the important points of all the rest of them. I've listed on the next two slides information that the FDA has identified audit opportunities and policy areas. And there's about 16 of them. Let's review a few of these in a little further detail. I'll just kind of read them now, but we'll get into detail in a couple. One is the inspection of records. Two is the registration of food facilities. 3 is the hazard analysis of risk-based preventative controls. 4 is the performance standards. 5, the standards of produce safety. 6, protection against intentional adulteration. 7, the authority to collect fees. And 8, national agriculture and food defense strategy. In addition, it talks about and gives great detail as far as the Food and Agriculture Control Coordinating Councils, building domestic capacity, the sanitary transportation of food, food allergy and anaphylaxis management, which is the reaction to food allergies, new dietary ingredients, requirements for guidance related to post-harvest processing of raw oysters, and the port shipping and alcohol-related facilities. Let's look at one in particular, the inspection of records. The FDA may have access to and copy all records relating to such article and to any other article of food that the Secretary reasonably believes is likely to be affected in a similar manner, that are needed to assist the Secretary in determining whether there is responsible probability that the use of exposure to the food will cause serious adverse health consequences or death to humans and animals. As you will note, the wording of the statement implies that the FDA has unlimited, repeat that, unlimited access to information pertinent to the contaminated food. Or does it? In food litigation cases, trial attorneys will represent both the plaintiff and the defendant. From the defendant's standpoint, your arguments very likely will be limited to the scope of information access, and the plaintiff attorney will probably claim broad information access. So this is something that, again, will have to be worked out as through case law. Talking about produce safety standards, it states that food that is certified organic, not included any requirements that conflict with or duplicate the requirements of the National Organic Program established under the Organic Foods Act of 1990. And as you can tell, that is somewhat dated, while providing the same level of public health protection as requirements under guidance documents and regulations under the FDA Food Safety Modernization Act. I do want to comment the fact that there previously until 2012 were two separate organic food certification organizations. One of them, called the CCOF, certified that the USDA National Organic Program standards and international standards, and the other was Oregon Tilk Company, and both are combined under one. So if you have cases that you're working with organic foods, there is one and only one certification agency right now. The organic food industry and locally grown programs continue to be worrisome to me personally, because most of these farmers do not have the financial resources for detailed compliance. That can either work to your favor or work maybe against it. Another key aspect of the Food Safety Modernization Act is what they call tracking and tracing systems. The Food and Drug Administration will establish a product tracing system to receive information that improves the capacity of the Secretary to effectively and rapidly track and trace food that is in the United States or offered for import into the United States. The government continues to use the words tracking and tracing systems, while processors remain mainly in the dark on what would constitute this solution. A wide range of software systems are being peddled throughout the world with ill-defined solutions. The best solutions use a combination of sophisticated barcoding capabilities, electronic documentation, and batch tracking. I will pause now for any questions that you may have before we move on to the second part of the presentation.
Okay, great. Thank you, Darrel. And for everybody in attendance, if you have a question, please feel free to submit it using the chat feature, which is found on the right-hand side of the screen. Darrel, we have had some questions that have already come in, so we'll get right to it. Darrel, what's the #1 food safety policy or program that a food company should have in place?
That's a good question. In my opinion, a product recall program led by a crisis management team that can be fully implemented within 60 minutes, that can demonstrate a consistent pattern of mock recalls and involves every department of the company. And what I refer to when I talk about a demonstrating consistent pattern, I think most of the attorneys on the webinar today understand that one of the biggest problems that a company could do is have a policy and not stay with that policy on a consistent basis. And that's really what I'm talking about here, is they have a consistent pattern of scheduled mock recalls along with the critical performance analysis of how that recall went.
Okay, great. Thank you. We have a question here from Justin who asks, what are the requirements to label your product certified, quote-unquote, organic? Where are those requirements available?
Usually what that means is to get that certification, it is a USDA organic certified label. And if you meet all the criteria of reaching that certification, and you can get that from either, this combined organization now, CCFO and Oregon Tilth Company, they will give you a certification document that everything is in place. Now, when I worked for Organic Valley, which is the largest organic food company in the United States, as I mentioned earlier, there are two types of documents that they have to keep, and they're almost of equal weight. One is a product specification, and the other is the organic certification. But when you are certified organic, then that gives you, as a producer, the right to put the USDA certified organic label on your product.
Okay, great. Thank you. Darrel, you spoke briefly about food security. What do you think is the most likely broken link in the food security chain?
The biggest mistake that any CEO, executive team, personnel, company officers can make is one word. It's called assumption. Assuming, and the mistake is that you're assuming the QA manager has done their job in your company, or you're assuming the international QA managers did their job, or you're assuming that QA data is entered accurately, or you're assuming long-term and trusted suppliers will keep flawlessly doing their audits. I just can't emphasize this enough. I've seen in multiple situations, and I'm actually working on a case right now, where there is evidence, and I have seen personally, QA people write invalid data into data log sheets that they have. And so everyone in leadership in the company needs to cannot make the assumption that there are no mistakes. They need to keep questioning the employees, keep looking at things personally, because I just believe they have that type of fiscal responsibility.
Okay, great. And we have another question here that asks, what do you think will be the most litigated aspect of the new law from a defendant standpoint?
I think there's probably four things. One is the thoroughness of record documentation. I do not believe, and my experience has shown, that even though the U.S. food industry and a lot of companies I've worked in are very good at this, I also have seen numerous cases where information that's recorded in their documentation, QA documents, is not complete, or is falsified, or just isn't thorough. The second would be the accuracy of the records documentation. The third would be consistency of policy and procedure adherence, and to make sure that the whole company is following on a consistent basis the food safety program and practices that they have agreed to follow. And lastly would be adequate training administered to employees. A company can have the greatest food safety program in the world, but if they don't, on a regular basis, train and update their employee training programs, they're soon to have a problem, and it can all be prevented.
Okay, great. We have a follow-up to Justin's initial question about what requirements are needed to label your product organic. Are there certain criteria that have to be met, or will those be found in the certification documents that can be downloaded from the two organizations?
I think you can get the information that's downloaded from the two organizations, but and I don't have time to go into now, but there are very very specific things you need to go through. For instance, if you want to produce vegetables on a piece of land, I believe that land has to be, I guess you should say, non-bearing, so to speak, or remain barren for about one growing season. When it comes to livestock, for instance, or such as raising pigs that are organic or chickens, there is a set period of time that the animal cannot have any or be exposed to anything that would be considered to be non-organic, and I think in a lot of cases that's around 3 months, and that could even apply to, let's say, a sow, which is the mother of pigs during her gestation period. So there are very specific time periods that either the animal or the land needs to remain somewhat barren, so there can kind of be a cleansing of impurities that are already there. Now, I've recently become aware of a company that thought they had organic certification. It was an imported grain, rice to be specific, and what they found out was that it was grown in organic soils, but there was some inherent contamination, such as, I think it was arsenic, that was in the soil that even though they thought they had an organic plot, it didn't pass muster because it was impacted by the soil and what was born in the soil. So, yes, the government does have very specific regs, and if you want to get on to kind of do a little Google on that, or you can get back with me through TASA, I can give you some very specific information. And part of what I did is put a lot of that together in another presentation that I taught my students at Johnson & Wales, the upcoming chefs, so that they have a basic understanding. So when they work with someone locally that says, we have an organic food product, we want to put organic food on our menu, that they're aware of exactly what those requirements are.
Okay, great. Thank you, Darrel. I don't see any other questions in the queue, so why don't we continue on with the presentation of content.
Okay. I'd like to talk now about the Food Safety Modernization Act requirement to improve, or their focus on improving the capacity to detect and respond to food safety programs. A couple key points here that pertain to that. One is the allocation of resources to inspect facilities and import food product according to the known safety risk of facilities of food, and to establish a product tracing systems to track and trace food that is in the United States or offered for import into the United States. The FDA has outlined approximately 10 key areas that a food processor can use as a guide to improving the capacity of detection and respond to food safety programs. Number one, this slide has the implication that it refers to the concept of benchmarking against a baseline. In other words, if you look at the second line of this, it talks about food according to known safety risk. In my mind, that refers to benchmarking against some kind of a bedline or baseline. Number two, it refers to the concept of quote-unquote true tracking and tracing systems. Tracking and tracing systems work better for large food growers and processors than small independent farmers. I can only help but to remember working on an olive processing plant in Spain earlier in my career and seeing farmers deliver a wheelbarrow of fresh olives. The FSMA would not allow this practice to continue, so there's got to be some of those type of screening and policy implications set in different countries. And companies just cannot afford to work with small producers anymore if they're going to bear the responsibility of risk. Again, I have a couple slides here. These two slides I'm going to go through itemize FDA focus areas with further explanation of the requirements in these areas. I will list these areas and dive deeper into a few specific areas. If you have any questions, again, make a note, submit them to the question and answer period or into the chat text box. I have 5 that are listed on this slide. The first is the targeting of inspection resources for domestic facilities. foreign facilities, and port of entry. 2 would be the laboratory accreditation for analysis of foods. And I'll just make one comment off to the side on this particular thing, because I worked on a case, and the attorney really wanted to have the food products tested in an FDA laboratory. And one of the FDA attorneys in a law firm here in Denver, Colorado, where I live, he used to work for the FDA, and the FDA pretty much restricts use of the laboratories to their own people and doing their own analysis. We looked into the possibility that there would be some other food analysis laboratories that do overflow for the FDA, and we really didn't have a lot of luck trying that. So it'll be interesting, because in this act, the FDA is saying we're going to expand laboratory resources, accreditation, just like we talked about. But whether they get the money to fund that and grow, they're going to have to grow. So there's going to have to be money come, or else there just won't be an enforcement of the law. Section 203 in this slide talks about the integration and consortium of laboratory networks. When we talk about laboratory networks, the question could arise, if the FDA certifies a particular laboratory results, can that be used as a substitute in a court of law in an FDA case litigation? And that'll have to be explained a little bit further, and we'll probably have to get more insight from the FDA on that. The most common example that I could think of right offhand is when I worked for some of the restaurant companies. Tyson Food has a approved collaborative analytical laboratory, probably one of the best, if not the best, in the whole food industry. And arguments could be made that since they're approved and they have a great reputation, why couldn't their results be used equivalent to what the FDA is? But that'll just have to be something that will have to be worked out in the future. And then Section 2004 talks about enhancing tracking and tracing of food and record keeping. Section 205 is on surveillance. And then number 6 here is a mandatory recall authority. 7, the administrative detention of food. 8 would be the decontamination disposal of standards and plans. 9 would be improving the training of state, local, territorial, and tribal food safety officials. And let me tell you from experience, it is just mind-boggling for food companies that sell food in different states and different cities, because a lot of times there just isn't standardization of what the regulations are, and it is very frustrating. Hopefully there will be some standardization of these different organizations. And then Section 210 talks about the enhancing of food safety, and 211 is improving a reportable food registry. I don't mean to list these to be boring, but I do want to allow you to be exposed to them so that you know these are the key areas of the Food Safety and Modernization Act. When we talk about improving the safety of imported food, we talk about the requirement of certification for article of food imported or offered for import, and it complies with applicable requirements of this Act. And that it also includes the entering into arrangements and agreements with foreign governments to facilitate the inspection of registered foreign facilities. Let me comment on this. This slide itemizes a certification requirement in our government's role in getting foreign governments' cooperation to coordinate registration of foreign processing plants. There's also a program known as the Foreign Supplier Verification Program, and how it will work. The FSVP, which I just referred to as the Foreign Supplier Verification Program, requires importers to conduct risk-based foreign supplier verification activities to verify that imported food is not, among other things, adulterated, and that it was produced in compliance with the FDA's preventative control requirements and produce safety standards where applicable. And one of the best ways that I know from being technically trained and receiving a PhD in food science, when we talk about verifying activities, I always go back to statistical significance analysis of variance, so that you can be accurate at least at a 95% confidence level, 99%. I really believe that whatever is done by a food manufacturer needs to be based on statistical significance at those two levels. Food safety requirements also require that the U.S. importers, that they need to perform risk-based foreign supplier verification activities to verify that imported food is produced in compliance with applicable requirements related to hazard analysis and the standards for produce safety, that is not adulterated or misbranded. And you'll see through this presentation a couple focus areas that I've tried to highlight, because I just believe these are areas that are most vulnerable. One is produce. Another one is imported foods, just because almost 30% of all the organic food in the United States, for example, as I mentioned, is imported. And we're just becoming an interdependent world community. The FDA also has another program, as opposed to what I just showed you, and it is a voluntary qualified importer program. And it goes by the name, or the letters of VQIP, Qualified Importer Program. It's very voluntary. And won't force the FDA to rely heavily on inspections by foreign governments. Section 302 of the statute requires the FDA establish a voluntary, user fee funded voluntary qualified importer program to expedite entry into the United States of imported food from eligible qualified suppliers. To be eligible to participate in this voluntary program, an importer must offer food for importing from a facility that is certified by an accredited third party. The FDA will qualify eligible importers to participate in the VQIP based on risk consideration. The new law directs FDA to issue guidance on participation in and compliance with this voluntary program. And I guess another way of visualizing this program is kind of like the Air Traveler Clear program that most of you probably are familiar with that do a lot of traveling. So this is a similar type of program. It's a way to qualify or pre-qualify some of the international companies that have outstanding programs and that are trusted. On this slide, some further explanation of the Food Safety Monitors Action, that it requires a certification article food imported or offered for import complies, make sure that it applies with this act, and that the companies enter into arrangements and agreements with foreign governments to facilitate the inspection of registered foreign facilities. What aspects of the FSMA do not cover imported foods? Well, under provisions of U.S. law contained in the U.S. Federal Food, Drug, and Cosmetic Act, importers of food products intended for introduction into the U.S. interstate commerce are responsible for assuring that the products are safe, sanitary, and labeled according to U.S. requirements. All imported food is considered to be interstate commerce. In other words, the FDA is not authorized under the law to approve, certify, or license, or otherwise sanction individual food importer products, labels, or shipments. Importers can import foods into the United States without prior sanction by FDA as long as facilities that produce, store, or otherwise handle the products that are registered with the FDA and prior notice of incoming shipments is provided to the FDA. And that is key, letting the FDA know ahead of time that the shipments are coming into a port of entry. In addition, imported food products are subject to FDA inspection when offered for import at U.S. ports of entry. The FDA may detain shipments of products offered for import if the shipments are found not to be in compliance with U.S. requirements. Both imported and domestically produced foods must meet these same legal requirements in the United States. There's another list of different Act sections that you can take a look at. that have to do with safety of imported food. They refer to the Voluntary Qualified Importer Program. I just talked about that. The authority to require imported certifications for food. Prior notice of imported food shipments, which I just mentioned. And the building capacity of foreign governments with respect to food safety. This will be one that's probably going to have to be worked out politically because, not all countries see food exactly the way we do, and there will probably be some negotiated agreements between individual countries. And then in Section 302, we have the inspection of foreign food facilities and the accreditation of third-party auditors, as well as the foreign offices of Food and Drug Administration and smuggled food. I want to take a look at basically Section 302 here when it talks about accreditation. Will in-house laboratories set up by a company for test its own food be eligible for laboratory accreditation per FSMA? And I talked about that previously. But valid analytical results are essential to make informed decisions that impact public health. At its heart, laboratory accreditation is about laboratories consistently producing valid results and focusing on assuring management requirements for the operation and effectiveness of quality management system within the laboratory, and two, the technical requirements that address the correctness and reliability of these tests. But the FDA has not fully developed its thinking or rulemaking with regard to FSMA implementation. So we've talked about this before, but it's just something that, again, has to be clarified as time goes on. Again, this slide talking about food certification. Another related example of certification document upon a food product delivery is what they call a certificate of analysis document that is used now in the shipment of all food products. It is more of a product analysis certifying that the product meets ingredient and product specifications used to purchase the food and distribute across state lines. So I do expect some of this food certification to kind of take on some of the prior characteristics of the certificate of analysis. So we talk about some miscellaneous provisions. This directs the Secretary to increase the field staff of such centers and offices, and establishes a whistleblower program, protections for employees of entities involved in manufacturing, processing, and balancing, packing, and tracking distribution of food. And I'm just speaking from personal experience. I think some of the pressure that quality assurance people that work in food plants, some of the reasons why there's some adulteration of data is that people just flat out don't want to lose their job. So I think the worker whistleblower program is really needed so that people feel free to do the right thing and enter the right data and not be feared about losing their job. Some of the other miscellaneous provisions are funding for food safety, employee protections. When we talk about employee protection, this talks about a person who believes that he or she has been discharged or otherwise discriminated against by any person in violation of subsection A, which states that may not later than 180 days after a date which such violation occurs on file, or have any personal file on his or her behalf a complaint with the Secretary of Labor. When we talk about the liability reduction of food safety prevention processes, I've listed some things that I think are well worth summarizing at the end of our presentation today. And one is for record best practices, whether that be manual, electronic. Best practices also includes legible and accurate time-stamped information. One of the only ways to get time-stamped information is probably to use software systems that keep electronic log of when information was entered. Some of the program best practice would include real-time recall, which I personally recommend, and then support HACCP program, HACCP risk and metrics based. And then a third best practice would be performance measurement. And that would be a performance standards based on pre-risk assessment, good manufacturing practices, and current technology capabilities. With regard to produce best practices, This refers to the growing, harvesting, and sorting of packaging and storage operations of science-based minimum standards related to soil amendments, hygiene, packaging, and temperature controls, animals in a growing area and water. And also to consider hazards that occur naturally that may be unintentionally introduced or may be intentionally introduced according to the acts of terrorism. Some food safety prevention practices, other best practices include post-harvest processing of raw oysters, port shipping, new dietary ingredients, alcoholic beverages, food allergies, sanitary food transportation, food safety, or food supply chain security of international basis. I'll go back to, I think it's the third bullet point here on new dietary ingredients. There are continually new products coming onto market, and even in the organic sector that are brand new natural sweeteners or other type of food functions, whether it be colorants and that kind of thing. And that's what I mean by that. And some of these just haven't had any case law providing any guidance for people in these areas. Then the next slide is ways to improve the capacity to detect and respond to food safety programs. Mandatory recall authority that the FSMA now has is the major hammer. It also refers to the adulteration and misbranding, the compliance resource level, the recall ban and capability, mock recall documentation. In other words, all these four areas that I've talked about here need to really be in place, or the food processor is going to have a real hard problem defending a problem that came up. I am concerned about the recall authority because, you know, how much food product that can be recalled, and what is their process to go through that, and can so much product be recalled that the food company, even though the problem is located in maybe one processing room, can the whole company be shut down? Will the government have access to all the records? And all these things are just things that need to be considered. But improving the capacity to detect and respond to food safety problems, foodborne illnesses are a big one. And that involves developing improved epidemiological tools for obtaining quality exposure data and microbiological methods for classifying cases. And then the automatic electronic searches for implementing of the identification practices, including fingerprinting strategies for foodborne infectious agents, in order to identify new and rarely documented cases of foodborne illnesses and submit those standardized information to central. We talked about improving the safety of imported food. We have the supplier verification program, which I just talked about, the voluntary qualified importer program. I won't go into any further detail since we've talked about those. But in summary, some of the common themes that I see from the Food Safety and Modernization Act are guilty until proven innocent, a government plant takeover or shutdown, and data declarance. That sums up my presentation today. I'm open for questions at this point.
Okay, great. Thank you so much, Darrel, for a tremendous presentation. We do have a couple questions in the queue. And for everybody who's in attendance, please feel free to submit your questions either through the Q&A feature or the chat feature, both of which are found on the right-hand side of the screen. So we have a question from Mary Jane, who asks, what are the best practices regarding the post-harvest processing of raw oysters? What does this entail?
I don't have that information at hand right now, but I can get it, and if you contact TASA, I'd be glad to provide you an answer for that in detail.
Okay, great. Mary Jane, I'll follow up with you after the program to get the contact information. Darrel, what is the biggest food security gap in the U.S. food safety system, in your opinion?
The biggest security gap is a lack of foolproof farm-to-fork tracking and tracing systems. The best system is always a combination of software and barcoding systems, because you can track lots of food, starting at the farm and detailed barcoding tracking of what they call WIP, or work in progress. In other words, what happens typically in a food or meat processing plant is that the meat will come in from different lots, and then it will be blended and mixed together during the grinding process, and it kind of gets lost there. So there really needs to be some some extra special tracking and barcoding that some companies are doing for that. Most folks, companies don't understand this, and there just hasn't been a focus on electronic software systems, but I believe it's going to happen.
Okay, great. Darrel, can you go over the core tenets of the FSMA as it relates to imported foods again?
Okay, I think there's several. There's maybe 4 things that I could mention. One is that all imported food is considered to be interstate commerce, pretty much like moving food from California to Arizona or something like that across the state line. Second would be the FDA is not authorized under the law to approve, certify, license, or otherwise sanction individual food importers, products, labels, or shipments. But they're going to be checking for that. A third point that I would suggest would be that importers can import foods in the United States without prior sanction by the FDA as long as the facilities that produce, store, or otherwise handle the products are registered with the FDA and prior notice of incoming shipments is provided to the FDA. And then a last point that I would add to those 3 previous ones would be imported food products are subject to FDA inspection when offered for import at U.S. ports of entry. The FDA may detain shipments of food products offered for import if the shipments are found not to be in compliance with U.S. requirements. Both imported and domestic produce foods must meet the same legal requirements in the United States.
Okay, great. Darrel, do you have any sense of the timeline for issuing the regs on this piece of legislation?
Well, it's my understanding the way the government processes work is that specifics to this act and specific regulations are going to evolve with time. They're not only going to happen at one particular time. And a lot of the regulations will be issued and modified and adjusted through case law. And so I would say that will happen over the next 5 to 10 years.
Okay, excellent. You briefly touched on the phenomenon farm to table that's happening across the country. Can you briefly touch on a couple areas of liability that farm to table, either the restaurants or the growers may face?
I think from a liability area, a producer or owner or grower of vegetables and produce and that kind of thing really has to have some kind of a surveillance system on their products so that they know what's going on. And I would say a good example of this is I've done some work in California in the produce industry, and there are attempts to make sure that product that is grown is maybe so many feet or so many miles or portion of miles from a processing facility, for example, where contaminants couldn't get onto the produce. Or they are so far away that if, let's say, dairy cow manure, which since dairy is a big industry in California, it is not applied to fields that are close to other fields where those contaminates, E. coli or whatever, could happen. So it gets into those situations, just being aware of the history of both the soil that the plant is grown in and the product itself and the whole path it goes through. That, I think, is one of the main risk factors.
Okay, great. I don't see any other questions in the queue, so why don't we wrap up today's webinar. Darrel, do you have any concluding remarks that you would like to make?
I just want to thank everyone for listening. I hope it's been beneficial. I wish wish it could be more specific, but that's kind of the nature of new laws, and be glad to help you in any way that I can. You can reach me through TASA.
Okay, great. Thank you so much, Darrel, for the time and the effort that you put into this presentation. And thank you to everybody in attendance who took an hour out of your busy schedule to spend with us. Just very briefly, I'll wrap things up. If you'd like to speak to Dr. Suderman about a specific matter, you can contact us here at TASA. Telephone number is 800-523-2319. As I indicated during the introduction, I will send out the link to the archive recording of this webinar tomorrow morning. The archive recording of this webinar, as well as all of our past webinars, can be found in our Knowledge Center. If you visit our homepage, tasanet.com, and click on the Knowledge Center tab down at the top of the screen, you'll be directed to the webinar section. Our next webinar for legal professionals, Survey Research Methods, Designing Survey Instruments, will take place next Thursday, September 20th at 2 p.m. Eastern Time. If you have any follow-up questions or comments, please feel free to email me at mhyde@tasanet.com. You'll be receiving an email from me at about 3:30 this afternoon thanking you for attending. You can just reply to that email with any questions or comments that you may have. We do take all of your comments under consideration, and they do help us to produce better programs. With that, I will end today's program, and I look forward to seeing you at future events. Thank you so much.